Three, two, one.
This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon and welcome to the Court of Appeals. We appreciate you participating in these Zoom oral arguments that we've been conducting today. And although it's not exactly the way we'd like things to be operating, it's the best we can do under the circumstances. So we certainly appreciate you participating. We will conduct today's oral argument just as if you are in the courtroom, which means each side gets 15 minutes to make its oral argument. If you're the appellant and wish to reserve rebuttal time, I assume you've already done that with Mr. Hibner, and you'll be given that opportunity during the argument. Before we start our oral argument today, I'd like to introduce the panel to you. We have Judge Arnold Golden from Memphis, Judge Harmon McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case then.
Samuel Lee Bachelor Jr. versus Aja Michele Burrell.
We'll hear from the appellant.
Thank you, Your Honor. Judge Stafford, Judge McGee, Judge Golden. My name is Daryl Blanton. I am a member of the Memphis Shelby County Bar, and I am counsel on behalf of Aja Burrell. I'd like to request 5 minutes of rebuttal. I believe Mr. Hibner's already put that on the clock for me.
All right, sir. You may proceed.
Your Honors, this is a case about the contractual obligation of attorney's fees in a marital dissolution agreement. The case is somewhat different from some of them that you've seen in the past, but it's very similar in that the marital dissolution agreement provided that in the event that Ms. Burrell had to file a petition to enforce a portion of the marital dissolution agreement, then she was to receive her attorney's fees. The language in the marital dissolution agreement, which is found on page 10 of the marital dissolution agreement, is very specific. Should either party incur any expense or legal fees as a result of the breach or non-compliance of this agreement, should either party be caused to file a petition for specific enforcement and or contempt of court relative to this agreement, or should either party otherwise be caused to litigate to collect from a party, estate, or third party any sums or property to be transferred or received herein consistent with any portion of this agreement, whether contractual or otherwise, the court shall award all reasonable attorney fees and suit expenses to the non-defaulting party after such hearing and upon appeal. So the parties signed a marital dissolution agreement in January of 2019. The court granted the final decree, approved the marital dissolution agreement, and signed a final decree in that same month, January of 2019. Pursuant to the marital dissolution agreement, Mr. Bachelor was to do specific things within certain times. One of those was he was to transfer retirement accounts within 60 days. One of them was that he was supposed to pay attorney's fees. One was he was supposed to reimburse health insurance. And another was that he was supposed to provide proof of the existence of a life insurance policy showing Ms. Burrell as the sole irrevocable beneficiary. And none of those happened in the timely manner set out in the marital dissolution agreement. So in April of that year, a petition for contempt was filed on behalf of the wife, and it was set for hearing. A response was filed. Motion for continuance was filed. The court granted the motion for continuance, and the case was set 4 or 5 different times over the next 9 months. Well, during those 9 months, Mr. Bachelor was able to finish and comply with the things that were complained of in the actual petition. He was able to get the retirement money transferred. He caught up on his health insurance payments. He was able to, he eventually paid the attorney's fees, and ultimately provided proof, or proof was provided. I shouldn't say he provided it. Actually, the attorney then for Ms. Burrell subpoenaed the life insurance records, and they were given to Ms. Burrell. But eventually it was shown that he had complied with the terms of the marital dissolution agreement.
Let me ask you this. The court made a finding that this non-compliance was beyond his control. Does that in any way impact this argument? I mean, in other words, it didn't appear. I mean, I guess it's a question. I don't know that you have to have intent to have breach of contract necessarily, but if something is beyond your control, that certainly can impact your ability to perform. And it seems like the court took that into consideration in determining that you were not entitled to attorney's fees.
Well, I'm going to answer that, Judge, in two parts, if I may. First of all, there was not one iota of proof that it was beyond his control. The proof in this case was very specific because only one person testified. Only the wife testified, or ex-wife, Ms. Burrell, testified. Mr. Bachelor never testified that it was beyond his control. Mr. Bachelor never put on any proof, never gave any exhibits that it was beyond his control. So from that standpoint, it shouldn't have any bearing. But the second part of the answer is, no, it doesn't have a bearing because contractually in January, Mr. Bachelor agreed to furnish, and I'm going to use the life insurance policy as the example in this case. Mr. Bachelor agreed to furnish a life insurance policy to Ms. Burrell that showed she was the sole irrevocable beneficiary of a life policy in the amount of $110,000. He was to do that and furnish the entire policy at the time of the final decree. He did not do that. Now, this was in January of 2019. The MDA is specific when it says he is to, I'm looking for my marital dissolution agreement. If I may read it, he was to furnish that at the time of the decree. He didn't do it. And so in April, the petition was filed. He still didn't do it. In June or July or in all of these different court hearings, he never did it. Ms. Turner, who was representing Ms. Burrell at the time, in October issued a subpoena to the life insurance company, and that's how she got it. It was never delivered by Mr. Bachelor to Ms. Burrell. So for the court to come in and say he couldn't do it, I think what Ms. Patterson's argument was to the court at the time was when they got divorced, Mr. Bachelor was attempting to say, well, I had a life insurance policy through my employment that was $175,000 and she was the beneficiary and they just wouldn't give me the policy. But that's not what the contract called for. That's not what he agreed to do. And so the answer is no, he can't rest on the fact that somebody else might have had something different because the agreement was very specific.
So in other words, this language from the court then, I assume what you're saying is the court had no proof on which to make that determination.
That's exactly right, Your Honor. And as we know, and I think one of the things the court did was the court looked at all of the pleadings and understand, I think there are 6 volumes of transcripts that are part of the record in this case. But there's only one volume that includes any proof, and that's the last one. All of the other ones are counsel talking to the court and asking questions, the court asking questions, them telling the court where we are in this process, and the court with his notes and looking at the pleadings, making this determination. But as we know, allegations in the pleadings are not proof. Documents attached to pleadings, they're not proof. The fact that the court read a letter from Ms. Patterson to Ms. Turner that was attached to the pleading called a response isn't proof. So the only proof that we have is the testimony of Ms. Burrell and the exhibits that were made, the documents that were made exhibits at the time of the hearing. And so if you go back and you look at those exhibits, some of them are letters, but all of the letters are from either Gail Horner, who represented Ms. Burrell, or Kay Turner, who represented Ms. Burrell. They're all saying, when are we going to get this document? When are we going to get this issue? This is an issue. For instance, Gail Horner's letter says, here are the issues that are outlined that he hasn't done. Those issues were then outlined in the petition for contempt. Ms. Turner said, when am I going to get the life insurance policy? She wrote a letter, I believe, in June, in September, in October, even into November of 2019, asking about these things. Those are the only exhibits that have to do with it. Mr. Bachelor put on no proof, presented no defense, nothing that would say that he wasn't able to do it. It was outside of something he was capable of doing. And so when you look at it from a proof standpoint, the only proof is that Mr. Bachelor didn't do what he was supposed to do, and that triggered the specific language in the marital dissolution agreement, which should have caused the court to award her attorney's fees.
Thank you.
Thank you, counsel.
All right,
We
thank
will
you.
hear from the appellate.
Good afternoon, Justice Stafford, Judge McGee, and Judge Golden. I'm Teresa Patterson. I am the attorney for Samuel Bachelor, the appellee in this matter. First, to address the factual background of this case, Mr. Blanton uniquely omitted from his recitation of the facts the allegations in the petition filed by Ms. Bachelor, which alleged in part, filed by her new attorney, Ms. Horner, that her previous attorney, Ms. Turner, had entered into an agreement as with regard to payment of attorney fees with her husband that she did not authorize or approve of. That was the crux of the legal action that she brought in this petition for contempt. There were some other allegations regarding tasks that had not been completed, and several of those tasks required the cooperation or help or assistance of Ms. Bachelor's attorney to complete. So I think it's clear that even based on Ms. Burrell's testimony, I should say, that Mr. Bachelor always had a life insurance policy naming her as the beneficiary. That's contained in the technical record. During her testimony, she acknowledged that there was never a time that she was not covered by the insurance. But what really caused the delay and the inability or to perform pursuant to the contract was the disruption in her representation and the switching of horses in midstream that delayed the completion of these tasks. There was no testimony from Mr. Burrell at the hearing. The hearing was to be limited to determining whether attorney fees were appropriate. There were no remaining issues regarding tasks that needed to be performed, and the parties stipulated and agreed that he had completed all of the tasks. To be candid with the court, I anticipated that Judge Russell would award some type of attorney fees based on all that we had been through. And I did not think that it was necessary to go over and rehash all of the issues that had been brought up in the contempt petition because all the tasks have been satisfied. But I will note for the court that the provision in the marital dissolution agreement regarding attorney fees does specifically state that attorney fees would be awarded to the non-defaulting party. And in reviewing the record, it appears that Ms. Burrell was in default of at least one provision of the marital dissolution agreement, that being her failure to return or reply to the draft of the qualified domestic relations order that was furnished to her attorney within the contractually contemplated time limit. The marital dissolution agreement specifically provides that the parties may from time to time have to provide each other with documents or information, and that they're to do so within 14 days. The exhibits, there is a letter from Ms. Turner in the exhibits that states that she was going to look over the quadro and get back, respond to it. That letter was dated February the 12th, and Ms. Turner never responded to that letter, and certainly not within the 14 days. So I think the issue in this case, and I think the case law is pretty clear with regard to the court's need to make a contractual interpretation, and the language did not include prevailing party. But the language in this particular marital dissolution agreement references a non-defaulting party, and it's our position.
Ms. Patterson, let me ask you about that language. Are you saying that doesn't apply to the specific default? In other words, if one party defaults on a particular thing, such as not providing the life insurance policy, then the person to whom the life insurance policy is, who's supposed to get the life insurance policy, is the non-defaulting party. In other words, it's applicable to each cause of default, is the way I'm looking at this. Is that a misinterpretation of the language? Are you saying if somebody defaults on one thing, whether it has anything to do with all the other defaulting provisions, that person is considered to be a non-defaulting party?
I think that's a broad interpretation of the language, but when the default is directly related to the task not being completed. In other words, one of the allegations of the petition was that Mr. Bachelor did not prepare a qualified domestic relations order as relative to the Tennessee Consolidated Retirement within the time frame that was contemplated. That order was prepared. A draft of that order was submitted to Ms. Burrell's attorney, then Ms. Turner. That order had to be signed by Ms. Turner, signed by Ms. Burrell, and there was no way to complete that task and submit that order for entry without their assistance. And they defaulted by failing to respond or to the draft within the time period that would have allowed the appellee to complete the task. So
but Mr. Burrell didn't testify to that.
He didn't, Your Honor, but Mr. Bachelor didn't testify to that.
I mean,
But-
excuse me, Mr. Bachelor.
Mr. Bachelor didn't testify to that, but I believe Ms. Burrell's testimony was that she initially signed an order that her second attorney, Ms. Horner, had reviewed and approved in June, but the gap in the approval of the qualified domestic relations order occurred when Ms. Burrell fired Ms. Turner and hired Ms. Horner. And one of the letters that is in the exhibits from Ms. Horner early on in March says, Mr. Bachelor has not provided a qualified domestic relations order. And that simply was not true. Mr. Bachelor had provided that order to Ms. Turner, or we had provided a draft of that order to Ms. Turner.
So at what point in time, and we may be arguing about something that's absolutely irrelevant, and I mean that with all due respect, because if your client didn't testify and if that proof's not in the record, then I don't know how we could consider it. But following your line of argument, at what point in time was the quadro sent to the wife ex-wife, and at what point in time did she not return it? Was it prior to the time this petition for contempt was filed, or I'm just trying to get my chronology straight here.
It was prior to the time that the petition for contempt was filed. I didn't print out the exhibits, but I believe one of Ms. Turner's letters that was or should have been included in the exhibits referenced her receipt of the qualified domestic relations order. I know that letter was attached to the response that my client filed to the petition, but I don't know if it was included in the exhibits that Ms. Turner admitted during the hearing. She admitted all of the correspondence, so I don't know if that letter was included.
Okay.
But I recognize that there are some things that were not put into evidence. Again, I may have been, we were having a hearing on an award of attorney fees, and I assumed that the court was going to award some type of attorney fees just because of the back and forth that had to take place to get these tasks accomplished. I would also point out that I think based on Ms. Burrell's testimony, there was evidence for the court to conclude that performance of some of the tasks at least were beyond Mr. Bachelor's control. I think the court in its statement said beyond the control of both parties. So I do think there was sufficient evidence presented for the court to find that. I think the court read through all of the correspondence that Ms. Turner submitted, and after reviewing that, he made his ruling. The reference to the prevailing party is not the language that's in the marital dissolution agreement. I'll have to concede that, but I do think that based on everything, all of the evidence that the court considered, that he may have not used the most accurate reasoning, but I do think he reached the correct conclusion that it would not be appropriate to award attorney fees to Ms. Burrell in this case.
Those factors that I don't want you to beat yourself up too bad, Ms. Patterson, but in this on this proof issue, are those are matters that probably could be brought up in determining the amount of attorney's fees that would be ordered?
I would agree with that, Your Honor, because I do think that the provision in the marital dissolution agreement does reference reasonable attorney fees. And I think that if the case were remanded for a hearing for the court to determine what would be a reasonable attorney fee, I think at that point, evidence of what efforts were made to comply with the task, what complications were encountered, and what caused some of the delay would be relevant to the reasonableness of the attorney fees.
Thank you.
That's all I have, I think.
All right, thank you. We will hear from the appellant in rebuttal then. You're muted, Mr. Blanton. You're muted. There you go.
There we go. Thank you. You know, we've done this and I still don't unmute myself. I want to kind of go backwards from the last couple of things that Ms. Patterson spoke about. You know, as she said, she anticipated that there would be an award of attorney's fees from the back and forth that was necessary for Mr. Bachelor to comply with the terms of the marital dissolution agreement. That's the exact problem that we've got here. When Ms. Burrell filed her petition, Mr. Bachelor, acknowledgedly so, had not performed pursuant to the marital dissolution agreement. The case was continued and continued and continued. The first time it was continued at Mr. Bachelor's request. 3 times it was continued, I believe, just simply at the court's request. And so ultimately, by the time they had a hearing in February, 10 months later, Mr. Bachelor had had time, the back and forth, to figure out exactly what he was supposed to do to get things done. Now remember, the proof was that Ms. Burrell had to issue a subpoena to get the life insurance documents. Okay, so even at that point, although it was accomplished, he didn't accomplish it. So the court, in looking at all of the pleadings and all of the notes, determined that because at the time of the hearing, it was acknowledged that the issues that were in the petition for contempt had been accomplished, he couldn't say that Ms. Burrell was the prevailing party.
Let me ask you this. It sounds like some of this had to do with the fact that there was the change. There was this change in attorneys on your client's side. There was first she had Miss Turner, then she had Miss Horner, then she had Miss Turner again. And part of this had to do, one of these items that's in contention is this $3,500 in attorney's fees that supposedly there was some deal made between your client, Miss Turner, or somebody, Miss Turner. And then you've got this other, I mean, how much of this, is some of this involving the attorneys?
No, Your Honor, actually it's not. Let's talk about that attorney fee issue that Ms. Patterson raised. So Mr. Bachelor was ordered to pay $3,500 in attorney's fees back before the parties entered into the marital dissolution agreement. This was from a temporary support hearing back in, I'm going to say, the summer or fall of 2018. He was given 90 days to pay, I believe. He didn't pay. He didn't pay any of it. So at the time of the marital dissolution agreement, he still owed $3,500. So he signs a marital dissolution agreement that says, I'm going to comply with the order that was entered from this temporary support hearing, and I'm going to pay that $3,500. Then he enters into an agreement with Ms. Turner that says he's going to pay her the $1,000 a month. That happens in February. Then he is told through Ms. Horner that Ms. Burrell didn't agree to that. Now, understand he still owes $2,500 at a minimum in attorney's fees. It's just a question of, does it get paid to Ms. Turner or does it get paid to Ms. Burrell? At the time the petition was filed in April, he hadn't paid it. At the time that the hearing was had in February, he had finally paid it. He never paid it within the 90 days. He never put on proof that he paid it within the 90 days. He never put on proof how that $2,500 was paid, how any of that affected or should affect his inability to say, I performed, I was not in contempt, or I did what I was supposed to do in the time frame within which I was supposed to do it, because he didn't. And then he didn't put on any proof about it. So there's not one iota of proof that Mr. Bachelor ever paid, whether it's $2,500 to Ms. Burrell and $1,000 to Ms. Turner, or $3,500 to Ms. Turner. There's not any proof. So let
me ask you this. Let's just for purposes of the argument, let's assume that we were to remand this back to the court. Would you do you agree that the court can take proof on this and can take these factors into consideration?
I don't think so, because I don't think you get two bites at that apple. Okay, Ms. Patterson,
you're gonna get two bites at the apple.
I shouldn't. Here's why.
Well, I mean, what other relief can we give you?
You can just award the attorney's fees. Ms. Patterson said that the purpose of the hearing in February was simply to determine how much of attorney's fees. I understand the remand, and I think the key issue is, if you remand it, can the court take proof as to the reasonableness? And in a defense of reasonableness, will Ms. Patterson be able to put on some of this proof? Maybe. But the idea that the court could say, I'm going to, or put on proof that says, now Mr. Bachelor's going to come in and say, well, I complied with all of that. I think that's,
I mean, I don't know how the court's going to look at that, but I mean, it's understood that he's complied. I mean, that's not really an issue, is it?
Not now. It's understood that compliance has been accomplished through the filing of the petition. And so,
but my point is that what happened up to the time of that hearing is really what we're talking about. I mean, he had complied by the time of that hearing, isn't that right?
The compliance had been completed. That's correct.
Right. So what we're talking about is are these other circumstances for which there was no proof taken. I mean, you're saying that he didn't testify, he didn't put on any proof as to how the court could have made that ruling. And I'm just saying it seems like those are the types of things the court could take into consideration in determining the amount of the attorney's fees.
I can't disagree with that. That's correct. But I
Right.
think I think what the question that you asked me was, could we reopen the proof so that Mr. Bachelor could then come in and say, okay, well, I did that back in, if the petition was filed in April, I did that back in May, so I'm still within a 30-day time limit of when the petition was filed, versus coming in and saying it was unreasonable to file that because I had already done it. That make sense?
I'm not getting into what the proof would be, but
Okay.
from what I'm sort of basing this on the fact that there was no dispute about the fact that at the time of the hearing, everything had already been done.
That's correct.
You're asking for attorney's fees. I'm just saying, but you can look back and to see what the circumstances, he could testify about what the circumstances were up until that led up to that time as to why things had not been done in a timely way. That's all.
Okay. And with that, I cannot disagree. That's correct.
All
Well,
right.
let me ask you one question then, following up on what Judge Golden has said. The contractual language itself in the MDA talks about the non-defaulting party. Ms.
Correct.
Patterson has pointed out that at least in today's argument, there was something that your client failed to do. I don't know if that actually was presented as proof in the trial court, but isn't that something that the court would have to take consideration of unless that has been waived at this point in time, if this case were to be remanded?
Okay. And see, that's kind of what I think what I was talking about with Judge Golden is my answer would be no. They had their chance to put that on at the time in February. And so today they're saying that the judge could have determined that Ms. Burrell was a defaulting party, but there's not any proof of that. And so the fact that they didn't put on any proof, and the fact that I believe what Judge Russell did was read pleadings and attachments and notes, not base it on proof, says there's not any proof that she was a defaulting party. And so
Was that even pled? Was that even pled?
No, sir. I don't think so. I from the standpoint of saying that Ms. Patterson pled that the quadro had been delivered to Ms. Turner, that answer is yes. In saying that as a result, Ms. Burrell was a defaulting party, that answer would be no. I don't know that a specific was made, but I don't remember, and I'm not looking at it right now.
But in other words, it wasn't raised in response to your petition for attorney's fees or it was a counter petition or anything like that.
Correct. And I know that it was not raised in Ms. Patterson's cross-examination of Ms. Burrell.
Okay. We could go on for a while, but I think we're going in circles at this point in time. So.
Yeah,
Well, I appreciate it, and I hope I answered all your questions. I'm sorry that we went over.
Well, you've answered all of them we have so far. So anyway, thank you for your argument. Thank both of you for your argument. Thank you for your participation in this, and we will attempt to get you an opinion as soon as possible.
Thank you, judges.
Thank you,
Ms.
Mr.
Patterson. Thank you, Mr.
Hibner.
Hibner.
Thank you, Ms.
If you
Patterson.
will,
Thank you. Good to see you.
Good to see you.
This
If you'll-
honorable court is now adjourned.